Thanks, Larry. Welcome. Good to be back. Many of you have seen this type of presentation before. I do it every year. This happens to be 2016. For the repeaters, I did it in 15, 14. What do we cover? What's going on right now at the IRS, which will include how many people are working there, will include the problems that the IRS is determined by the taxpayer advocate, what's happening in exam, what's happening in collection, what's happening in CI. Then we're going to move to hot topics that are going on now. Some have been on my list of hot topics for a couple years. Some are newer hot topics that you should know about. We're going to spend a lot of time in the latter part of the presentation on the new collection initiatives that are going on that you may not have heard about. So that's where we're going today. We'll cover as much as possible. You got a 90-page outline there. As you know, I'm from Chicago. I can't cover 90 days in 90 pages in 2 hours. If I was from New York, I could. I don't talk that fast, though. But maybe there's a little more substance to the Midwestern talk than the New York talk. I don't know. We'll try. So let's look at the numbers of staffing. As you know, Congress keeps cutting the budget of the IRS year after year, which hurts us, particularly when they've cut over $1 million to their $2 million in cuts. $1 billion in their $2 billion in cuts right out of enforcement, which is exam, collection, and CI. And as you see, the gross amount of revenue officers is down to 3995 as of September 30th. What's even worse, well, I'll show you a chart in a minute, of how many are actually out in the field doing collection and not doing special projects. But we've had a 1/3 reduction in revenue officers. What does that mean for us? The level that they're coming out on income tax returns is going up and up. In Chicago area, revenue officers don't go out on the street on an income tax liability unless it's above $250,000. What happens to the others? Well, ACS pursues them. If they can collect them there, fine. But if they are not collected, they go in the queue and they sit there indefinitely. So in Dallas last year, the Dallas Morning Star had an article in April 2015. You know what the level is in Dallas? $1 million. So if you owe less than $1 million in income tax, you can duck ACS. You go into the queue and you stay there. They file a lien and they don't bother you. Now that's crazy. But that's what's going on in collection. Why would Dallas have a higher number than Chicago? It had a better job market. People were quitting in Dallas, and they haven't hired anybody since 2010. And so there's no backup. When somebody leaves, retires, or leaves for another job, there isn't somebody else hired like we've always had in the past. Every year they had a training class up to 2010. They haven't had one training class since 2010 because they haven't had the money to hire people. Revenue agents, they were holding up pretty good with attrition, but the last 2 years, it's going badly. More baby boomers. People stay there, it's a good job, you're making $110,000, $120,000 a year, but sooner or later, why not take the lucrative pension and go out and work for one of you guys? If you can get 70% pension on $120,000 and go out and work too, it sounds like a pretty good idea to do it. So we're down now to 10,800 from 12,000 some couple years ago. Special agents, the same thing. Now, what is this going to show you when we move on? The level of audits are going down. The number of matters they can collect on are going down. Criminal investigation is going down. So each of them impact our ability to get business. We need an aggressive, nasty IRS. the more misery they cause, the more money we make. And if they aren't going out and bothering people who are making $220,000 in my town, I'm missing a lot of good engagement fees, because I like those people who run up big tax bills and then have a revenue officer there aggressively telling them what they're going to take away from them. And if they can duck ACS, they don't even come to us, because that revenue officer is what really motivated them to come pay my retainer. This is the overall staffing, which I just have through 2014. They didn't issue a chart this year in their data book, but you can see that in 2009 they went up, in 2010 they went up. The last George Bush budget gave the IRS a budget increase. They saw it as a way to help balance the budget. You give the IRS more money, they're a profit center. The first Obama budget gave the IRS another bump up, so 2010 was the high point, and then you can see what's happened with overall staffing since. Now, what's the effect of that? The attrition rate is much higher in the low-paid employees than at the revenue officer and revenue agent level. If you're making over 100 grand a year, you're not shopping your resume. If you're making 35,000 a year harassing people on the phone at ACS, what are you doing in the evenings? Looking for another job. And so their clerical staff has gone down at a higher percentage. We've gone from over 90,000 people that at the start of 2015, it was at 78,000. At the start of 2016 fiscal year, in October of 2015, it was about 74,000, and it continues to trend downward. One difference this year. In the 2016 budget, the IRS got more money to answer the phones. They didn't give them any money for enforcement, they gave them more money to answer the phones. Because let's talk about what happened last year and what happens this year. Last year, they answered 30-some% of the calls to the 800-1040 number. The other people never got through. They had a courtesy disconnect. They'd sit on the phone for an hour, a recording would come on saying, "We're sorry, we can't get to you." They'd cut them off and they'd have to come call back. Instead of letting them but the phones would load up so much, nobody could have gotten through. To avoid busy signals, they cut off the people who'd waited the longest. Now, how did that happen? Well, Congress cut the IRS budget for 2015. The commissioner had a choice with those cuts. To meet that budget, one, he could have every employee in the IRS laid off for 2 days without pay. So if it's 80-some thousand employees, he could have said, we're going to do a layoff across the board, revenue officers, revenue agents, everybody. Or he could cut out hiring the temporary employees they always hired in the spring to answer phone calls. So the practice of the IRS has been hire WAEs in January, when as employed, to answer phones. They would answer phones until April 15th, knowing they'd get laid off then, and they'd always hire 1,000, 1,500 people to do that. Last year, the commissioner said, I'm not going to hire the temps because I don't want to lay off my more productive, high-income, highly trained revenue officers, revenue agents, and others. So it was a tough choice. He made it. But what happened? They went from a 70-some% answer rate to a 30-some% answer rate. So Congress called him in to whip him. You know, there's even a comment in one of the articles this week about the way the IRS is being treated by the Congress. The beatings will continue until morale improves. So they called in a commissioner and said, why didn't you answer the phones? And he told them why. So in this year's budget, they gave him enough money to hire 1,000 temporary employees. And the statistics are about a 70% answer rate. Now, even if you get through, though, and get an answer, the accuracy rate is only about 70%. So the last time I computed that out, you're only getting about a 50% right answer rate. Even though they're answering more calls, they still answer 30% of the questions wrong. And they're not allowed to answer any of the tough questions because remember, these are temporary employees hired for 3 months. So if you make a call with a tough question, you think you're going to get an answer at all? No. You're people who are very sophisticated. So that's what was going on. It's continuing downward. But yesterday, 2 days ago in the Wall Street Journal, the Internal Revenue Service is going to hire 700 employees for tax enforcement this year. They found some money in the budget somehow or other. So we have some hope. Since 2010, no revenue officers, no revenue agents. We've lost about 5,000 of them. But we're going to back up now. We're going to get 700, which is good. Let's hope that that profit margin they show by hiring these people makes it so Congress finally gives them some money to start hiring. I think they're doing it by just finally filling in for attrition. They've lost so many people, they finally can afford to hire a few more. And obviously new hires get paid less than the departing revenue agents and revenue officers. So it's the first significant enforcement hiring in more than 5 years was a headline in the Wall Street Journal on Tuesday of this week. That's good. We need that. Now, revenue officers, and I know you can't see this very well, but remember I had a chart up there saying at the end of 2015 fiscal year, there were 3,900 revenue officers. This chart comes, I saw a presentation in January from the head of collection for the country. And he has only 2,900 and some of those 3,900 revenue officers are actually on the street investigating. Some of the others are working in the technical section. Some of the others are doing special projects, but they have about 4,000 people who are revenue officers to collect, but only 3,000 of them are out banging on doors and saying, I'm here to collect the money. So that's the impact of this drop. Back in 2010, which we started at before, of the 60-some hundred revenue officers, they had 4,200 on the street. But literally, they still have about the same amount in the back rooms, but there's a lot fewer on the street. So the attrition rate is even more pronounced on actual, I want the money revenue officers out on the street. Now, one of the things that's been in and out of the headlines is regulation of honor roll preparers. And I've talked about this before, so I'm not going to spend a lot of time on it. But we have about between 800 and 900,000 people who do tax returns for pay in this country. Of that number, only 300,000 have a professional credential, a CPA, enrolled agent, or attorney. What do they all have in common? They all had to take a test to get their credential. They all have to go to continuing professional education to keep their credential. And they all went through a background check to prove that they weren't convicted felons, criminals. But we have 500,000 people in this country who do tax returns for pay who do not have a credential. They haven't been tested. They haven't been required to go to continuing education, and they haven't gone to a background check. So in my state, I can be released from state penitentiary having done 3 years for robbing 7-Eleven stores. Job market's a little difficult because I'm a convicted felon. I can borrow money from my dad, open a storefront saying tax returns prepared, buy software, and I'm in business. And that's the case in 46 of our 51 jurisdictions in this country. There are 5 jurisdictions that regulate preparers: New York, Maryland, DC, California, and Oregon. Oregon has the toughest system. There's a test to do individual returns and a test to do business returns. Last year, they had legislation in Congress proposing to regulate preparers because the IRS had lost in court on the issue. In 2004, they lost in the D.C. Court of Appeals. That court said they could not regulate these 500,000 people. But Oregon has been regulating them for years. When they had testimony in Congress last year in 2015 regarding regulation of these preparers, the state that has the best quality returns prepared is Oregon, strangely enough. And then the other testimony showed from the IRS, here's what it is. The highest quality returns they receive are from enrolled agents and CPAs. People who've been tested, smart enough to pass tests, continuing education to stay up to date, and they're not crooks. Second best returns they receive are self-prepared returns from taxpayers. And the worst quality returns they receive are prepared by these 500,000 uncredentialed people. They're the people doing phony EITC, phony education credit, phony deductions and exemptions to get their people bigger refunds. So last year it came up, was ready to go through the Senate Finance Committee. A couple of the senators who are very conservative said we don't want any government regulation of anything. They put a courtesy hold on it, didn't go through. This year came up, was up for final markup last a month or two ago. Same senator stepped up, said we don't want government interfering with the freedom of these 500,000 crooks, and they put a hold on it. Legislation did not go through. So there's very little hope that we're going to be able to regulate the crooks in this. Now, there is some positive. They create more business for us because they do bad returns, they give bad advice, and eventually a very small percentage of their clients get caught. And for me, some of them do get indicted, and I get to defend the crooks. So that's good, too, because I get my biggest retainers when somebody gets indicted. I just had 2 this week that went from civil investigations to criminal investigations, and the next thing I had to do is I called the client and say, I got some really bad news. I just got a call from a special agent saying they're opening a criminal investigation from this civil one that you had. They figured out you didn't report $500,000. And oh, by the way, I want a lot more money. That's good. Anytime a lawyer gets paid, that's good. You don't like that rule, right? Then you always have heard my corollary, right? The corollary is better. Anytime an enrolled agent or CPA gets paid, that is good unless the bill went to Bob McKenzie or my law firm of Arnstein and Lear. We like that one? Okay. So, what is the IRS doing? Well, in 2014, they announced this voluntary program. And the voluntary program allows the people who voluntarily take a test from a private vendor to claim a credential as an annual filing season preparer. And the one thing that they gain, that the IRS took away from the unenrolled people as of January 2016 is, up until January 2016, if I prepared a return, I'm one of the 500,000 that's uncredentialed, I was allowed to file a power of attorney if that return was audited. So when I screwed it up, I could then file a power of attorney and represent the client on their behalf before the IRS. As of January 1st, the only people who are allowed to file a power of attorney now with the IRS are enrolled agents, CPAs, attorneys, or voluntary program participants. And they are not allowed to do any collection matters. So if you find a client who's being represented by an unenrolled preparer, the next thing you should be doing is write a letter to the Office of Professional Responsibility saying this person is filing powers of attorney without authority. because they're our competitors. Let's try to put them out of business. Let's try to get them in trouble. Because we have a credential, we have the right to represent people unless they have entered that voluntary program. Now, how can you find if they're in a voluntary program for audits? There's a national database. You can put in Kay's name right now, Kay Welly. If you go online with the internet, go to irs.gov, search the database of people who are enrolled agents, CPAs, attorneys, and voluntary program participants, and you can find her phone number and address for business so that people can check out the credential of each of us. Now, when I went up online last year, though, I searched my name. I'm an enrolled agent and an attorney, and somehow or other they missed me. I don't know who I pissed off, but they did put me back on the database. Okay. In 2015, in June, Nina Olson announced a new taxpayer Bill of Rights. And in the PATH Act, which was the one for highway funding that was passed last year, there were a lot of tax provisions, and included in it was the adoption of Nina Olson's taxpayer Bill of Rights. But unfortunately, many of these rights that are now in the law do not have a remedy. So if the IRS violates them, there's not much we can do. Yes, it's the law, but big deal. Let's get to it. The right to be informed. So you had the right, according to the manual before, now in the law, to say, why am I being audited? And the IRS is supposed to tell you truthfully, well, you were chosen by computer, or we received other information. They're not required to tell you because Sid, your next door neighbor, ratted you out, but they're supposed to give you some indication of why you're being audited. So you have that right to be informed. It is now statutory. My problem is, I don't know of a way to sue them if they say, go to hell. I don't know a remedy. It's in the law, so you can point to it in the law, but it's not, there's no penalty for not doing it. The right to quality service, that's mom and apple pie. And I'm sure that's high on the list of some of these revenue officers that are overstressed and overworked right now to really, I want to make sure I do this job correctly. The right to pay no more than the correct amount of tax, well, we always had remedies to sue on that. If you think of it, if they audited your client, you get a 90-day letter, you get the right to contest it, right? And if they sent your client a collection due process notice demanding too much money, you can file a CDP appeal on a 12153 and say the liability's wrong. There's a mistake. So we've had that one. It was never so specifically stated as this, that you have the right to have the correct amount. The right to challenge an IRS position and be heard. The manual is contained, right to appeal during an audit, right to appeal collection matters, just another emphasis on that right. If it's a statutory right, we can enforce it to some extent, like the CDP rights are statutory, and we have the right to go to tax court. If they levy without giving you a CDP notice, you can go into tax court to stop it. And with an audit, if they assess without having given you a 90-day letter, you can contest that. Independent forum. By law, since 1998, appeals has been independent. Used to be, I'd file an appeal, and the appeals officer could call up the agent and say, what do you think about this guy? There's now rules since 98 saying that's ex parte communications, not allowed. So the agent is not supposed to be called by an appeals officer. The revenue officer is not supposed to be called by a settlement officer after you appeal unless you agree. So this is just another clarity of what the law has been since 98. The right to finality. Well, you have a right to finality if you sign the right form. If you sign a 4549, which is the standard way you close an audit, that says at the top, waiver on restrictions on assessment. You know what that does for you? It allows the IRS to assess. But if the agent made a mistake and the case gets assigned next year on another year, if that year, let's say they audited 2012, let's make it 2014. They audited 2014. You sign a 4549, and next year your client's 2015 return gets chosen for audit, and the new agent spots an issue missed by the first agent on 14, she can open that audit because you signed a waiver on restrictions on assessment. And what's that mean? It's still open during the 3-year statute. They can come back and redo it. But if your client signed an 866, an agreement to final determination, a closing agreement, they may not come back. So almost every audit closes with a 4549, which means legally they reopen. Now here's the flip side. Your client went to an audit on her own, was intimidated by the tax compliance officer at the office audit, and she signed something she never should have signed, agreeing to more money. She signed it on a 4549. Guess what? Your client has the right, if she only signed a 4549, to pay the liability, file a 1040X asking for a refund, and if they won't give her a refund, she has the right to go to court and sue the IRS. But first, when they refuse her refund, she has the right to go to appeals and appeal it. So what does a 4549 do? It allows the IRS to assess, but both the taxpayer or the IRS can reopen that same year as long as the statute hasn't expired. But if you sign an 866, no right for either side to contest it. Now here's the worst one though. If your client signs something known as an 870 AD, she can never reopen the audit, but the IRS can. That sounds like a really fair form. So why am I going through all this? In some of my other materials and the lectures I've done for this group, you'll find all this. But when it says the right to finality, you have the right to finality if you signed a form that made it final. But if you didn't sign a form that made it final, it isn't final necessarily. The right to privacy and the right to confidentiality, 6103 of the Internal Revenue Code, provisions requiring you as a practitioner to keep your client's information confidential. The 75-25 privilege, for example, for enrolled agents and CPAs, you can't tell your client's secrets. So those are all in the code. These are just saying in layman's language what we as professionals know about. 6103 about disclosing clients' tax information is another code section. So basically, very clear definition, but I don't know of any additional rights to privacy other than stating it very clearly now in the Internal Revenue Code, nor additional rights to confidentiality. Yes, sir?
You filed that 1040X that you said. What's your reason for filing?
You state right on.
4549.
Okay, you state on there the original exam was incorrect. The taxpayer agreed to a liability in excess of what she should have agreed to, and here are the mistakes. Put a narrative on it. She agreed that they should disallow all of her travel and entertainment expenses. She actually did have travel and entertainment expenses. We disagree with that. That issue is there. So you go through line by line on the 1040X for all the things you disagreed with, put a narrative on. They can, if they deny it, you have a right to go to appeals because you never went to appeals in the first place. You don't win there, then you got to sue in U.S. District Court or the Federal Court of Claims. You don't get to go to tax court.
Now, would you include documentation to prove those T&E costs, like you said?
I would. I would add everything on, make it so they don't, one of my theories in dealing with the IRS, you've heard it before, anytime you make somebody at the IRS think things go wrong, do all the thinking for them, do all the work for them, And then it's easy to say, oh my God, Alexi's already got it together here. We don't need a fight with Alexi. Whereas if they just get a 1040X with nothing else, well, let's just deny it. But if it looks like it has merit, you got a better chance. It doesn't mean that you're not going to get a bad person reviewing it who says no. I mean, we've all had good IRS employees who did their work right and employees who don't want to do any work. So if they don't want to do any work, the easy choice is denied. And that's just the way it goes. The right to retain representation, that's been in the Internal Revenue Code since 1988. The original Taxpayer Bill of Rights gave that right to your clients. It's still there. This is just an easy thing. And the reason this was originally published by Nina Olson is the IRS is now handing out these rights to taxpayers who come under investigation. What the Congress did is just simply make this part of the law. But what I'm pointing out is a lot of it doesn't do much. And then the last one. This one is certainly, I'm going to be able to sue on this. The right to a fair and just tax system. Okay, I get Vlad the Impaler for an agent. Let's see, what's my lawsuit to say when I have an unfair agent? I don't know of any damages. I can come into tax court and contest what the agent said, but I don't have a right to sue and say he didn't act in a fair and just manner. So it's just pure aspirational in my view. It's not of any value. But it is the law, and it seems to me it would help in bargaining. If you get a particularly confrontational IRS employee and they've missed a few of these points, it might be worthwhile pulling out the taxpayer rights that are now statutory and say, tell me how this is meeting the standards set forth for you to do your job. It may just irritate him more that you're doing that, but I've never minded irritating jerks. If they're a jerk, I can be a jerk. In fact, I'm a lawyer. I do that better than being nice. But next thing we go to, and I do this every year, because every year the taxpayer advocate is required by law in January to issue a report to Congress of the 20 biggest problems in the tax system. And every year, Nina Olson, who's been around doing this for 10 years, issues a list. Last year on her list was, we need a taxpayer bill of rights. In June, she issued her own, and actually in the fall, Congress in the highway bill adopted this list that she put in her taxpayer of rights. But taxpayer service, the IRS has developed a comprehensive future state plan for taxpayer service. And here's what she thinks is wrong with this. And it's good narrative to look at. The plan is to almost do everything by computer, not answer phones, not have people at a desk to answer questions. That's the master plan. Now, why is the IRS commissioner adopting this plan? Resources. Limited budget, so what's he doing? Cutting back on personal service. But Nina's point is, one, think about senior citizens who don't know how to use the internet. They need to talk to a real person to comply with the tax law, either walking up to a desk or making a phone call. Think about people who are not well educated, not sophisticated, who don't have the means. Think about poor people who don't own computers like everybody in this room and are using them every day in their life. Even if they could go to a library, would they know how to turn on the computer and make it work and get the information? So this plan is omitting a certain part of our population by saying we're going everything internet. They're going to leave out some of the people who need advice the most. User fees. One of the things, it's even had some hearings on this in Congress, is the IRS gets to keep user fees. It's one way to supplement budgets. So they can choose a number on user fees. And when we get to collection later, we're going to look at a year or so ago, they raised all the fees for installment agreements, offers, and compromise. It's another way to supplement their budget. And she said they got to look at whether that has compliance impact, and she thinks they should look at it. As you know, Congress has held a lot of, number three, Congress has had a lot of hearings since the disclosure of the 501c4 scandal and holding up application for some of these alleged community service organizations that were actually political organizations and not giving them tax-exempt status. So the IRS said, we're going to just automatically give anybody who asks for it tax-exempt status now without much review. So they now have a 1023-EZ. And that sounds like a great idea. You know, let's stop all the bureaucracy. If I want to be a charity, let's do it. Okay, there was a flood in Houston this past month, right? Hey, that might be an opportunity to make some money. I'm going to form Bob McKenzie's charity saying, flood relief for Houston residents. I'll file a 1023-EZ for my new organization, Flood Relief for Houston Residents, and I'll begin soliciting donations on the internet saying I'm a charitable organization. You can get tax-deductible donations for helping the people out in Houston. And that's her point, is any crook can now come in, say they're tax exempt, and the IRS will find out about it later, maybe. Whereas before, when I applied to be tax exempt, there was a review by a professional to decide whether at least I met a minimal standard of establishing I should be a charity. But now, to make it easy and to avoid scandals, let's just give it to anybody who asks for it. And if we make a few mistakes and a few people make donations to crooks, big deal. Okay. Revenue protection, hundreds of thousands of taxpayers file legitimate returns that get flagged. And the IRS is not, and any of you who do preparation have had some of your clients have their refunds held or their processing and returns. And they don't have an adequate system for resolving these problems when they're a legitimate return and they shouldn't have been flagged. And it ends up going to her office on a 911, because those of us who know what we're doing will file a 911 when they jerk us around on a flagged return. But what happens to the group of people who are not sophisticated? They lose their refunds. So her point is they got to look at a way to, once they do get a false positive, how do they take that hold off? And there isn't an easy system to do that. Online account system. Well, this is you've heard all the scandals on that. We used to be able to go in and get our transcripts right online, individual taxpayers, right? Then some Russian hackers stole 110,000 names and all the private financial data for our clients who could go on themselves just because of the ease of piercing our system. So they shut that down now. To get a transcript, your client has to request it with a online request with identity verification or with a form itself. She's trying to say make it easier, but the flip side is hackers. How do you make it easier without the hackers being able to steal my private financial data? So there's a balance in that, in my view. Prepare access to online accounts. Creating on-credentials prepares access to online accounts could create security risk because they're proposing that. And what do you think? 500,000 people, none of whom have gone through a background check, some of whom are felons. And we want to give them all access to our clients' financial data. How many like that idea? So she points out a really legitimate thing is if you're not even checking the backgrounds on people, why would you give them access? Every one of the EAs, CPAs in this room, somebody did a background check on you. Doesn't mean you haven't turned into a crook, but at least when you had the background check done, you were not a convicted felon. International Taxpayer Services, they're closing down international offices because of resources. She's saying, well, people overseas need more services than people in the United States a lot of times because it's more complex. We're going to talk about it a little bit this later. They had implemented, because of staffing, the AJAC, and we've all heard about it here, process in appeals. And her point is, and it's my view too, it's reducing some of the protections we had for clients. One of the things they're doing in AJAC is, I file an appeal because I had a bad agent. He did a bad job on the report. It ends up with the appeals officer. Under AJAC, you know what the appeals officer does? Sends it back to that same bad agent to rework it. It used to be they tried to straighten out the mess at appeals. So it takes away that smart appeals officer we used to deal with, and it gets sent back to the same jerk who screwed up the audit in the first place and waste a lot of time in most cases. Collection appeals program. All of you have done CAP. You know what CAP does. Here's the review appeals does on a CAP appeal. Revenue officer denied my request not to file a lien. I'm filing a CAP appeal. All they review is whether it would be legal for the revenue officer to file a lien. So I get up on the CAP appeal, and they don't look at the merits of, hey, if you file a lien, my client's going to lose his business because he's floor planned on his car dealership, and as soon as the lien comes, they're going to cut off all deliveries. So, bottom line, I appeal. They said, well, it's legal for them to do it. We don't know if it's fair. And they rule in favor of the IRS. Another one on CAP appeal. I'd like an installment agreement, Mr. Revenue Officer. Denied. Here's my 9423 CAP appeal. Was it legal for the revenue officer to deny your installment agreement? Yes, it was. Appeal denied. So my view is CAP appeals are almost useless if all they're going to review is whether it's legal to destroy my client economically. Yes?
Yeah, the other thing that's bad about CAP appeals is there's actually an IRM site that says if you file a CAP, you can't file a CDP on that year.
Yes. You can't do a CDP if you do a CAP. So if you're within a CAP, if you haven't gotten your CDP, you're better off to wait for the CDP and get all your statutory rights. The other thing is, I have a lot harder time getting a 911 reviewed if I've lost a CAP appeal. So if they turn down an installment agreement with me, I file a 911. If they refuse to withhold filing a lien, I file a 911. I get a lot more sympathetic here because what does taxpayer advocate do? They look at the fairness of a process, not the legality. And it's absolutely legal for the IRS to file a lien, even if it would destroy your client's business. It may not be prudent, it may not be fair, but it's legal. So that 9423 you have in the draw, my best advice, take it out, put it in a shredder, and never, ever use it in the future. Use the 911. Moving on. Levies on assets and retirement accounts. Well, the IRS legally can levy on assets and retirement accounts if management approves. The frontline revenue officers can't do it, ACS can't, but with approval, a revenue officer can go to his branch, to his group manager and take them. They can take all the money out of a 401k. They can take 15% of your Social Security benefits, which they do regularly from ACS. And so she thinks, it can, and she's right, it conflicts with the policy of trying to leave people money for their retirement. But the problem with her comments there is Congress has authorized IRS collection to do that. So they can do it. So they can, and some do. Notice the federal tax lien, that the IRS files most federal tax lien based on an arbitrary dollar amount. What's that? Gets over $10,000, generally they're going to file a lien unless you enter into a direct debit installment agreement and it's under $25,000, then they will withhold a lien too. So if you do a direct debit installment agreement, a DDIA, the threshold becomes $25,000, they'll withhold a lien. Always ask for it when you do a DDIA. If you have a matter that does not have an agreement on it, gets to be $10,000, ACS generally will automatically file the lien if you ignore the CDP notice. Third-party contacts, the IRS is required since 1998 to give us a list of the people they did third-party contacts with. Not all revenue agents and revenue officers are doing that. It's always, if you got a bad agent, here's one of the things I do. I send them a letter and say, pursuant to the 1998 Revenue Reconciliation Act, I'd like a list of all third-party contacts you've made. Why would I do that? Well, if she's giving me trouble, I'll slap her around the other way. Make their life miserable. If they're doing that to your client, make them comply with the law. If they're good, reasonable agents, forget about it. I got a good agent, do I want to piss her off? No. I'm going to stay with my yes ma'am, no ma'am, may I kiss your butt ma'am approach. But if I got an agent that just wants to jerk me around from hell to high heaven, why not make her do a little work? Why not make her comply with the law? Why not create some record that she's not doing what the law requires for appeals? Whistleblower program does not meet whistleblowers' needs for information. When I file on a rat for a rat, they don't keep me informed of what's going on. I can write letters and they say, we're still thinking about it. Well, I don't know if they've completed the audit and they're now in appeals. I don't know if they've completed the audit, the taxpayers agreed, and they've collected it all. I'm just sitting there hoping that they will do something, but I don't know for sure and they won't tell me much. Affordable Care Act, just pointing out some of the problems they're facing implementing that. I'm going to leave that. Identity theft, the biggest problem at the IRS right now. More and more thieves finding more and more ways to steal identity. Every time they try to make it easier for us to get online information, somebody finds a way to pierce it. The biggest source for identity theft information right now, doctor's offices. How come? Every time I go in with a new doctor, what do they have? I fill out that sheet and it says name, address, date of birth, social security number, employer. All electronic. I am a thief. I go to a clerk in a doctor's office, give her a few bucks. She sticks a jump drive in a computer, takes all 2,000 patients' names, address, social security numbers, employers, directly off that computer. And what does that then give me the ability to do? Steal the identity for every one of those persons, because I have most of the relevant information that needs to pierce most systems. Yes, ma'am.
I had a client this year, 3/4 of the people at her employment identities were stolen, and it got tracked back to the payroll service that they provided.
Payroll service, too. Again, all it takes is one dishonest clerk with computers now. They caught a guy in Tampa who had, in the front seat of his car, he got stopped on some traffic violation and they ended up there searching, but he had 3,000 names printed out from a doctor's office. And what was his business? He was filing false returns on behalf of people with those 3,000 names. So it's an industry now. People have found that's a lot safer thing to do than stick up 7-Elevens. You can steal refunds and it's not dangerous. You don't have to carry a gun. There isn't the danger the clerk in the 7-Eleven has a gun too and shoots you. It's just a wonderful opportunity if you're a thief for earning money. Yes, sir.
IRS really needs to give us the ability to get IP pins. If you're a credentialed tax preparer or representative, if you have a power of attorney, you call them. They won't give you an IP pin. It has to be mailed.
You're right.
It's a mess.
It's all a mess. and they for a while there, they wouldn't give me information on the false return that was filed on behalf of my client. They now will give you a transcript of that anyway. So at least it gives us some ability to find out why our client can't get a refund and can't file her return to do it. But I don't know how we're going to overcome identity theft now when we're all so computerized. Our doctor's offices, our payroll services, and all it takes is one crook let somebody into it or a hacker who knows how to get into it, and we're all in a problem. Individual taxpayer identification, pardon?
Back up just a minute. You said that when you have identity theft, we are now able to find out, get a transcript for,
Yes, they announced that change last year
we don't do it in our office.
From the IRS agent.
from the IRS. So you got to request it from the,
That's called,
You have to go to the agent themselves?
or identity theft group. You can go to and ask for it.
taxpayer.
And practitioner hotline. Hotline won't? No, you got to go to the identity theft group, fax them a request with your power of attorney, and then they'll get it to you. And don't try calling the identity theft group. I'll mention this again later. Their answer rate last year at the identity theft group was 23%. So you got to fax them.
Well, tell me this then. What's the number to fax to the identity?
It's in the PowerPoint. We'll give it to you. I promise. It's a good question, but since I put it in the PowerPoint and I don't remember all these things, it's here. Okay, let's go. ASFR, well, she's criticizing who they choose to do the automatic substitute for returns for. Basically, she's saying they should go for a higher level dollar amount since they are not doing as many as they used to. They used to do about 3 million ASFRs a year, and now they're below 1 million returns that they're doing for non-filers. We have 7 million non-filers, and most people are getting a pass now because of lack of resources. And they have the 1099s, they have the W-2s. But given limited resources, essentially what her extended report says is, why aren't you using them on the biggest dollar amounts? Forget about the chump change for somebody with $40,000 in 1099s. Go after the ones with $400,000 first, if you can't go after them all. Seems like a logical thing to do, but logic and the IRS don't always match up. Okay, individual taxpayer identification numbers, really a problem. I had a call from a practitioner the other day asking for what to do. He had a foreign national who sold a building. They need an ITIN to report the profit from the sale of the business. So he applies for an ITIN, provides all the information required of that foreign national, and gets a denial saying, we won't give that to you until you give us a tax return, which is ridiculous. It's the chicken and the egg. How are you going to file a return if you don't have an ITIN? So my advice was simple enough, go to the taxpayer advocate because this is stupid. And then they'll order them to give an ITIN and then you can file. But it's just, that's the type of problems we're facing. Reductions in the priority case program. Remember, we used to call and in 10 to 15 minutes we got an answer from a competent person. What's the whole time you have right now in the priority service? You're calling it back there, sir.
Actually, this season, it's been under 5 minutes.
Really? Well, I've had to wait longer. IRS collection effectiveness. The IRS failure to accurately input designated payment. What's that? When I send in a payment and say direct to trust fund portion only on a delinquent withholding tax, it's supposed to be coded properly so that it goes to trust fund. And the point she's making is, even though the IRS is supposed to code it that way, they're not doing it. So we have the right to direct a voluntary payment, but if it's not coded on the computer as directed, we're going to have to prove it later when they start computing that trust fund penalty. Collection of it. Next one, exempt organization. The IRS delayed an updating publicly available list of EOs, harms reinstated organizations, and misleads taxpayers. So an organization that got its status back and the IRS doesn't update the list, nobody can find out that they are tax exempt and you can make a donation to them and get a deduction. Earned income tax credit does not do enough taxpayer education. Earned income tax credit is not adequately using EIT's examination process as an education tool. And lastly, the EIT's return preparer strategy does not adequately address the role of preparers in EID non-compliance. The last one I'm going to spend some time on. I've represented a lot of these less than honorable practitioners who literally game the system for EITC. And only a small percentage of them are under investigation. I had a woman in my office from Miami last year, and she did manage to get under investigation. I said, how many returns did you do last year? 500. And how many of them were good quality returns? About 100. And I said, she said, don't worry though, I was only putting my preparer identification number on the good quality returns. I did all the rest as if my client was self-preparing them. So there's some really good people out there doing this job. She hasn't passed the EA exam though. Okay, every year Nina Olson reports on what happens on the cases that go to court. Now, to give you some perspective, how many cases go to court? Well, last year, about 28,000 people went to tax court. And how many cases got tried last year? 300 and some, right? 600 and some. And of that, 396 were pro se, 244 had an attorney or an EA or CPA who passed the tax court exam representing them. In the win rate, without representation, 19% overall, with representation, 28%. So, the reason I put these statistics up here is when I get to appeals, a lot of times we get offered a partial settlement, right? Agent set my client up, let's take the one. Trade or business expenses. A lot of times agents will say, I don't care that you have a canceled check, I'm going to disallow the expense because you don't have the invoice that you paid. Anybody ever have an agent do that to you? When we get to appeals, you get a lot better treatment, right? But they might say, well, your client didn't have total adequate documentation. We'll give you 75% of those disallowed expenses. And we're going to take away 25%. You're saying that's a bad deal. But now let's see, what's my chance of winning if I go to court? 49%. So I got, what do I want? A 49% chance of winning all the expenses, or do I take bird in hand and take 75% right now? What do you guys think I should take? Now, when I'm talking to a client, these statistics help. Because everybody says, it's unfair. They can't do that to me. Well, the first thing I do, though, before I even get to this, is I quote what my fee is going to be to have a trial. That tends to change the standard of unfairness. But the second part is to get out these statistics. So if you're arguing about a penalty, you got a 27% chance of winning in court. You're arguing about trade or business expenses, you got a lot better chance, 50-50. Summons enforcement, IRS almost always wins those. Those don't go to tax court, they go to U.S. District Court. Your client doesn't comply with the summons and the IRS sues him, he's going to lose. That comes down to it. You better comply. Gross income, your client who doesn't report all the income allegedly, they don't do real well on their own, do they? Even with a practitioner, they're only winning about a third of the cases. Collection due process, you end up in court fighting about a CDP, you got a 1 chance in 4. That's the bottom line. So if you get offered a deal with the settlement officer, even though it isn't the best deal in the world, which I'm going to fight it, I'm going to court, 1 chance in 4, or take that not great deal. So I use these numbers, I keep them in my desk drawer, when a client says, that's not fair. And my answer is, there's nothing fair about the IRS. But if you get to court, you're going to pay me a lot of money, and you got a 1 chance in 4 of winning it. They're demanding you got to pay an extra $400 a month on the installment agreement. Which do you want? Pay me a lot of money, go to court, and have 1 chance in 4 of winning? or take a bad deal. That's what you have to do to sell clients a lot of times when you're up at a CDP. Failure to file, 18% chance of winning on the penalties. Federal tax liens where they foreclose. Occasionally the taxpayer will win on a foreclosure when the IRS sues for foreclosure. I won one a couple years ago. They foreclosed on my client's house. I proved the statute had expired on the lien they were trying to foreclose on. But I also have a whole series where my client lost her house. So I'm telling you the one win. But normally what happens? Let's see, 15% of the time. Charitable contributions, not bad. Frivolous issues, I'm not defending text protesters, so no big deal. One that you have a pretty good chance of winning on, taxpayers, the one exception here, taxpayers do much better on innocent spouse cases on their own than with practitioners. I don't know if we're taking the harder cases or not, but it is something you can win on. And we have pretty good luck on the innocent spouse. We've had some really good relief on innocent spouse, so keep that in your arsenal. Let's go now to how much they collect. Now, this is surprising to me. They're not going after as many people in collection. They have a lot fewer revenue officers. They're collecting more money. So they're doing okay there with fewer resources. Examination, look what happened in 1 year. We cut the IRS enforcement budget last year by $200 million. We lost $5 billion in audits alone. That's really good math, isn't it? Save the government $200 million. Don't collect $5 billion more in audits, so we only lost $4.8 billion by cutting the IRS budget across the board. Appeals, $6 billion came in, downward. Document matching, they're still running the document matches, still making money doing 1099 W-2 matches. $54 billion came on, but they did get in $3 billion less than the prior year, and they cut the IRS budget by $200 million. You think we might have made more money to leave that $200 million in there for enforcement and allowed them to have sufficient agents, revenue officers to go out and collect. Oops. Okay, now let's go on to audit rates. And I did not, the IRS statistic data book came out last month. They didn't break down income all the way through. So I'll come back to that. But at business returns, you'll see that 0.9% of business returns got audited under $25,000 gross revenue. 2.4% of it between 25 and 100,000. 2.5 from 100,000 to 200,000, and 2% for above 200,000 gross. The overall audit rate in 2015 was 0.8%, the lowest it's been since 2002. We're down from a 1.1% of all returns audited in the year 2010 to a rate of 0.8%. Now, the best place to get all those statistics are in the article that was published this week on Forbes that I wrote. I write a blog for Forbes, so this week my article was, you met the tax filing deadline, now what are the chances you face an IRS audit? And you look for the rate of audit is 0.8%, which is the lowest, as I said, in essentially 15 years. We are not getting to many people. And what I point out in paragraph 1 of this article is 87% of Americans tell the truth. I'm sorry, 83%. 17% don't. When we cut the IRS budget, who are we benefiting? The 17% dishonest people. Because instead of having a 1% chance getting caught, they have a 0.8% chance of getting caught. So I keep thinking about this, and I say, why would Congress do that? Because it's probably the 535 most dishonest people in the United States as a collection of people in our Congress. I mean, there's crooks and liars congregated there at a level that is unbelievable. So who would be their friends? Who would donate more to congressmen? Crooked businessmen who are cheating on their taxes? Or honest taxpayers who are paying everything they owe? Maybe, I'm a little jaded in this, but we are doing a tax cut for the cheaters because the chance of being caught is less. But I talk about business taxpayers, self-employed, and this paragraph at the bottom. But one group that gets audited more are low-income taxpayers. And that's because of the EITC, and in my view, partly because of the crooked preparers who are doing false EITC returns for those poor people. And so that the IRS does have more odds. But then everybody else, until we get to above 200,000, they are audited at a rate of less than 0.8%. So other than self-employed, if I'm somebody making $150,000 a year and I get a W-2 and a 1099, my chance of audit is about 0.5%. It's very low because the IRS doesn't have enough resources. High-income taxpayers, I have a breakout here on the middle of the second page, 200,000 to a million, 3.62, and these are the statistics right up here. Let me get back to these. In 2014, they did not release 2015, but it gives you an idea. In 2014, the audit rate was not 0.8% as of now, it was 0.86, 2013, 0.96. But for people with low income, it was 0.93. Look at here, 0.5, 0.5, 0.5 for all those categories up to 100,000, 0.6 for 100,000 to 200,000. They didn't do that good a breakout in this year's data book as they did last year's, the reason I'm using 14 figures. But now look at once you get to rich people. And once you get to over $1 million, 6%, 10%, 16%. But now, when you look at those last three numbers, look what happened between 13 and 14. There's a 1/3 drop in auditing rich people for every category above $1 million in 1 year. So, if we just look at this, well, who would be making between $1 million and $5 million? Well, that would be a light-hitting infielder for the Cubs who lets ground balls roll between his legs. And if we were between $5 million and $10 million, it would be a third baseman who actually could catch a hot liner down the line, right? And above $10 million would be any pitcher in the major leagues.
Or a guy that strikes out 200 times a year.
Or a guy who strikes out 200 times a year. Until recently, the Cubs have been good at finding those people. I have to admit, folks, I'm a Cubs fan, not a Sox fan. I'm a North Sider. North Siders root for the Cubs in Chicago. South Siders root for the Sox.
Not all of them.
Well, not all of them, but you can identify a Sox fan, though. It's because they will have at least 3 more tattoos and 2 more indictments than us Cubs fans. But back on point. But both teams are doing well this year. Give us time. Once we get to June, we'll swoon. Okay. Businesses, why are they higher rates? Because IRS studies have found that the biggest cheaters are small businessmen. Small businessmen have lots of opportunities to cheat. They can underreport their revenue. They can claim inappropriate expenses. Tell me how much chance you have to cheat if you get a 1099 and a W-2. Not a lot, right? So you know what the compliance rate of people who only get W-2s and 1099s and 1098s is? 98%. Overall compliance rate, 83%. Little bit of a gap. Self-employed people. On Schedule C's compliance rate, when they have done tests, have been around 50%. There's always something the guy's fudging. You say, well, none of my clients fudge. Okay. What about the Bears tickets? Do they always take business people to the game for those tickets they write off? Well, for last year, we didn't have to worry. There was a special IRS rule that came out. All Bears fans were allowed to take a casualty loss on their tickets. But for years when they actually could play football and didn't have a group of sissies out there, we had to be able to prove that we actually took somebody to the game that would have a business purpose, right? But you know that some of your clients are writing off those tickets for the season tickets, and they're taking their brother-in-law and their kid and their wife and all the other things for those tickets. And there's all those opportunities for self-employed people, one after another. And when the IRS audits them, that's the reason for the lower compliance rate. Now, you want to lower your client's business rate of audit? Here's the interesting thing. The IRS hasn't figured out that people who file S corporation returns and 1065s lie just as much as Schedule Cs. So let's look at this. 0.42%, 0.36%, 0.4%. 0.42, 0.42, 0.51. Let's go back a step. 0.9%, 2.4%, 2.5%, 2%. What do you think is the best method of doing business to avoid an audit? Certainly seems like a simple choice, doesn't it? Doesn't take a brain to figure that one out when you look at the statistics. Collection. Look at the impact on seizing people's bank accounts and wages on the IRS budget cut. 3.7 million levies on bank accounts and wages in 11, 2.9 in 12, 1.8, 1.9, 1.4. Now, what does that do to my business? Dramatically decreases it, because when do most of the people hire me? Just after the IRS levied their bank account. They ignore the CP14, the 501, the 503, the CP 504, the CDP notice, and finally, when did they call me up? I don't know why they levied my bank account. Did you get any notices from the IRS? Well, yeah. Did you ever get a certified notice from the IRS? Yeah, I didn't pick it up, but I... Yes, I heard there was a notice from the post office. Then they call me, but what it means is I have about 40% as many potential customers as I had back in 2011. So I'm getting fewer. Because if they levy fewer people hire us. Because that's when they're really desperate. Right after they lose their wages, right after they lose their bank account, and that's the impact of budget cuts. Let's go down. Liens. Million liens filed in 11, 500,000 filed in 2015. What's that? Many of you advertise to people with liens. Get a list of liens filed, send out your advertisement, saying, I represent people who are in problems with the IRS. I negotiate with them. We have half as many potential customers from lien list as we had 5 years ago. That's the impact. Seizures, no big deal. That's taking up physical assets, locking up your client's business, taking their car, taking some other physical asset. They don't do it very often. Even less now. I mean, it's down from 700 times to 400, but those are not a significant source of income for any of us. It happens so few times. Bank accounts and wages, lots of times. Seizure of physical assets, not often. Now, By contrast, before the 98 Act, in 1997, the IRS seized physical assets 10,000 times. So then that was a source of business. But now it's below 500. It's rare. You really have to piss the IRS off before they take your car or lock up your business. Okay. This one is a statistic that came out from the Government Accountability Office, which reported that between 2009 and 2014, uncollected tax debts rose by 23% to $380 billion. But during that same time, the IRS budget for enforcement was cut 23%. So how much was that cut? About $1 billion. So let's see. 23% of $380 billion. What is that, about $90 billion? So we increased the amount of uncollected taxes by $90 billion by saving $1 billion. Really makes sense, doesn't it? And it really hurts our business. Criminal investigation. Look at the impact in investigations opened between 2013 and 2015 as a result of budget cuts. Down by a third, right? Now, you notice that the other statistics did not go down as much. The people prosecuted, the people indicted, convictions. Do you know why that is? Pipeline effect. If they open an investigation in 2013, they may not charge them until 2015. It takes 2 or 3 years. But what we're going to see as the years go out, fewer people are going to get charged, fewer people are going to get convicted. Now, this really disappoints me because my largest retainers come from people who've just gotten their Miranda warnings. I would hope that they'd move up to 10 or 20,000 investigations a year. Or as I told the special agents in Chicago and Indiana when I lectured to their continuing education a couple years ago, I was invited in to do the other side. They had the prosecutors there, and then they let me come in for 45 minutes to discuss the defense side. But I said, I really like you guys, because every time you show up, I get a big retainer. But I'd like you to keep the investigation going for a couple years, and then give my client a no prosecution. And then I can look like a hero, and I can get more business from other people saying, Mackenzie got me off even though I cheated like mad. And they sort of liked me, except for the last part of that. But about 80% of people who get convicted go to prison. And the guidelines for prison, just in case you haven't heard it, are if you're below $100,000 in total taxes cheated on over a period of up to 5 years, the guidelines say 8 to 16 months in prison, but the judge can give you home arrest or probation right under the guidelines. And those are official guidelines published. Now, the judge can do what she wants, but when I have a client who's a lower dollar amount, many times probation is an option. Once you get above 100,000, and if you're below 250, the recommended sentence is 12 months to 18 months in prison. Now, if you shoot past 250 and get to 500,000, you get 18 to 24, and then 24 to 32, and so forth. So many of these people are doing a significant amount of time in prison. The one I'm negotiating on right now, I'm lucky. The computation came out that my client only cheated on $198,000 in taxes over 3 years. And so he's looking, we're going to plead guilty, because when he was being paid cash for his product, he signed receipts. And the person who was paid in cash got caught and turned all the signed receipts over. So I don't have the ability to deny that he didn't get the $500 and some thousand dollars or $600,000 in unreported income. So he'll plead guilty, and he's facing 12 to 18 months in prison. I then can go before a judge and argue, because of his special circumstances, he's such a nice guy, don't put him in prison, please. And the judge could choose not to give him prison. Or he could say, you know, I think 12 to 18 months is not enough time. I'm going to give you 2 years. They have guidelines, but they're not required to hit them in. So, an example, one that worked out well for me. My client was a realtor who forgot to report $1 million in income. And it was, you know, what happened to anybody. She got 1099s given to her by the broker, sometimes individually for her sales, and sometimes she had the broker give a 1099 to a corporation. And she reported all of the individual 1099s, but she forgot the $1 million in money that went into the corporate entity for some strange reason. And the corporate entity never filed any income tax returns. But for some strange reason, all the money ended up in her personal account. And oh darn, the IRS found it when they audited her, and then they referred her. And so my argument was, my client's 70 years old, she's a grandma, please don't put her in jail. And the special agent said, tough, she lied, she's a cheat, recommended it for prosecution. I went to Washington, D.C. and said, she's a grandma, please don't put her in jail. You know, no harm, no foul, we'll give you the money back for whatever we cheated on. Please don't put grandma in jail. And the prosecutor in Washington looked at me and says, Mackenzie, I've recommended that 80-year-olds go to jail, get lost. Well, that didn't work. So I came back to Chicago, and they had my client dead to rights, so she could go to trial or plead guilty. So we pled guilty. And then I wrote a long brief saying she's grandma, don't send grandma to jail, she won't be able to love her grandchildren. And Judge Yergin last month gave grandma probation for 3 years. But what she should have gone to jail for was 24 to 30 months by the guidelines, so she got a pass. But I don't always win that way, and that only happens about 20% of the time. But that's what it's about. The top prosecution priority per the Department of Justice right now is employment taxes. If you have a client who owes employment taxes, they are targeted. And if they're people who regularly don't pay their withholding taxes, they're indicting more of those this year than at any time in the past. Now, this past week, and this is not in your materials, they came out with a report on the tax gap. The tax gap was, on 2006 returns, $450 billion. What's that? The amount of lost revenue from people either not paying or not telling the truth or not filing. The next study that was announced this past week, instead of doing 1 year's test, they did it for 2008 to 2010. And the lost revenue per year from that now is up to $458 billion. But the interesting thing, the percentage cheating rate is higher. Because of the recession in those years, the total taxes that should have been collected by this country was $2.6 trillion in 2006 and only $2.5 trillion in 2008 to 10 as an average. But so the compliance rate in this country was 83% of our people do a correct tax returns. We've dropped to 81.7% of Americans are now complying with the law. By going out and doing enforcement and demanding late payments, the IRS collected $65 billion of the $450 in 2006. Because of reduced audits and reduced collection resources, it only collected $52 billion of the $458 billion for 2008 to 10. And so the net tax loss was up from $385 billion to $406 billion. So, more cheating, and because of less enforcement resources, we're collecting less and finding less of the cheating than we did in the past. So that's lots of opportunity for business out there. If they just start going after this $458 billion, we'd be in good shape. Now, one of the things they do is they should chart where's the cheating at. $387 billion of it comes from people who either lie about their income or claim extra deductions or expenses. And then, underpayment, $39 billion of it, people who file their returns and don't pay. And then we have, over on the left-hand side there, we have $32 billion for non-filers. So $32 billion non-filers, $387 billion from people who don't tell the truth, $39 billion. Now, color coding, what's the significance? The green, they know exactly how much is not paid with returns filed, $39 billion. So that's not a guess. The yellow, that's based on estimates. So they estimate how much cheating there is by doing these studies, these national research programs. And those little blue boxes, which are in corporate returns and excise taxes, they haven't done a study for 25 years, so they just put in no guess at all in there. They don't know how much cheating is going on at the corporate level. So these numbers do not estimate corporate income tax cheating at all, because they haven't done a study. And they don't estimate excise tax cheating. And so the estimated true liability is here. That's 100% of the tax gap. Then they show where they get it. Non-filing, individual income tax, non-filing is the biggest part. Then they talk about where do they lose the money. Business is 125 billion of that 387, even though there's a lot fewer businesses percentage-wise than just individual returns. And then they break out where the cheating's at. Corporation income tax, self-employment tax, they did do a study on that. They lose about $81 billion on that. Underpayment. But they're still doing these research programs. They're called National Research Program. They used to do them every 5 years. They now have one every year. And so they've been doing 10 to 14,000 returns every year since October 2007. So they studied 08 to 10, doing 10,000 or so each year, came up with these new statistics just now. Now they'll be working on 2015. They did employment tax ones for the first time from 9 to 11. That's the reason there were actual yellow estimates for employment taxes on the chart. And lastly, 2014, their returns, 2,500 of them are being studied. Remember the blue box on there? They're finally studying small corporations, see how much they lose. IRS appropriations, this is through 13. You can see how it was going down. It continued to go down in 14, 15, and 16. Once again, the budget was cut in 2016. Here's one effect of that. Unanswered letters going back for correspondence audits. This is from the National Taxpayer Advocates Report for 2014. In 2010, they had 600,000 pending letters for correspondence audits. By 2013, the backlog was at 1.1 million. So when you write back on an audit, guess what happens? They aren't even reading it. They don't have the people to read the letters, but they're assessing more money on these matches because they don't read the mail, but they still go ahead and issue the 90-day letter, and then the client doesn't go to tax court, and they're collecting more money, partly because they're not reading the responses of the taxpayer to the correspondence audits. Appeals. The appeals judicial approach and culture is the AJAC process. They're sending more things back to the field. They will not raise new issues at appeals now. They're not going to work cases aggressively like they used to, where they tried, if the agent did a bad job, they would go through and try to work it out. They're going to send it back to the field. Misclassified workers. Now there are things you need to know, and I'm going through this quickly. I may keep going on this after break with a few more things you need to know, but since 2011, the IRS has had a program for misclassified workers. Let's take your client. He's giving 1099s to people that should be getting W-2s. Happens a lot, right? And if he gets caught, and let's make it an easy number. Let's say that he's got a payroll that's 1099 for $100,000 a year, so $300,000 over 3 years. He gets caught, and if the IRS finds that he intentionally mischaracterized those workers, his liability will be over 40% for the assumed withholding and both sides of Social Security. So 40% of $300,000, that's $120,000 plus penalties plus interest if you get caught for mischaracterizing and you intentionally did it. If they find you didn't intentionally disregard the law, but you mischaracterized them, the penalty is 11%. 11% of $300,000, $33,000 liability, right? If you come in under this program and voluntarily confess before they catch you, the penalty is 10% of the 3509 rates, which are 11%, which is 1.1% for 1 year. So if your client comes in and confesses, he would have to pay 1.1% of $100,000 or $1,100 and agree that going forward he'll do it right. So that's the risk. If your client's really mischaracterizing, he can confess, pay a 1.1% penalty for 1 year, be safe from audit from the other years that are open, the other 2 years that are open, but he has to begin treating those workers properly. I did that with a trucking company that had 100 people mischaracterized. Think of the savings that you could have with truckers' wages at 1.1% versus 11% for 3 years, 1.1% for 1 year. So it's an opportunity, the form is out there, and they're doing it. Yes, sir.
Is this exclusive of if the IRS has begun an investigation?
If the IRS has begun an investigation, you're screwed. You cannot voluntarily come in there. You can try to work out a settlement, but you cannot do this if you've already been discovered. Yes, sir.
The Uber people, they came out with a lost case in California. Would you be kind enough to shed some light on that?
Well, I think that case may be an aberration, but Uber, here's their business model. I own my own car. I sign an agreement to be an independent contractor. I pay all the costs of my own car, and I get a certain percentage of the fare. And so what Uber's doing is taking a booking fee for getting me the fare. In California, the California unemployment people found that even with that they were employees. Whereas under IRS rules, I think that you'd find that they'd be independent. They have a risk of loss. They have to maintain their car, keep fuel in the car. They have to keep insurance on it. They could have losses because they pay more payments on their car than they earned in a particular month. So I think it would be hard to win federally. But California tends to take the view, if you work and get a paycheck and breathe, you must be an employee. So I don't believe federally that there's a risk, but Uber is looking at that. And there's some cities in California that are passing legislation that says Uber drivers must be employees. So certainly a city can pass that one. I would think I could win that case for Uber on a IRS basis. Yes, sir.
Country for the people who are around limousine companies. If the driver brings in his own car, they can be covered under this general definition.
That's
Versus the limousine company hiring the driver and then providing their own car.
That's exactly what the system has been coming out. And the example that I've won on all over the country is truckers. Trucking company has independent truckers owning a vehicle worth $100,000, comes in and hauls for them and gets so much a load or so much per mile, they have been universally found to be independent contractors. Trucking company uses their trucks, pays the drivers so much a mile, trucking company loses. Because all the risk of loss for that truck breaking down and all the other expenses of that truck is on the company. There's no risk of loss on the employees. So I think that the same thing applies for limo companies. I haven't had an audit of that, but when you look at risk of loss and investment, buying that $60,000 limo to drive and then having all the cost of maintaining it puts you at risk when you're contracting with a limo company. Whereas if you're driving the company's vehicle, your only risk is they don't have enough work for you. You're not going to lose money. You're just not going to get as much as you hope for. Whistleblower, it's still an active program. They have a new director, Steve Whitlock, who was directing the program, has been promoted. He is now the director of the Office of Professional Responsibility, which regulates us. A new lady's come in. But when you can file a Form 211 asking for a reward if you're ratting somebody out, and a 3949A saying what was wrong, and the IRS is accepting these. But look at the percentage of rejections. They paid in 2013 130 claims, but they rejected 2,700. 238 claims paid, 3,000 rejected in 14. In 15 through August of 15, 139 paid, 3,600 rejected. I still have several pending. So part of this, people trying to rat out things that don't qualify. What it qualifies, if it's a corporate allegation, has to be over $2 million involved. If it's an individual allegation, there has to be over $200,000 a year in income for the individual to qualify to be in the whistleblower program. If you do qualify and they do collect, then you have the right to get an award between 15 and 30%. The largest award ever made was for $100 and some million. That was Jeffrey Birkenfeld, who ratted out his employer UBS Bank for helping Americans hide money overseas. Birkenfeld was given his Miranda warnings. He said, "What if I try to help you get my bosses?" And they said, "Yes, you can." Birkenfeld helped him get UBS Bank. UBS Bank paid a $780 million fine. Birkenfeld was prosecuted, went to prison on a 30-some month sentence, actually 40-month sentence imposed by a judge down in Fort Lauderdale. While in prison, his attorney filed a whistleblower claim. When he was released from prison in 2013, the IRS gave him a check for $104 million as 15% of the $780 million that they got from his bosses. Had he not been involved in the crime, they would have given him 22.5%. So would you do 40 months for $104 million? Doesn't sound like a bad income. But that's the largest award ever given. Offshore program, they began their crackdown in 2009 with the charges against UBS Bank in February 2009. They've gone from only 300,000 people filing a foreign bank account. How much time do I have left? 1 minute? Okay. We'll do this after break. So how many minutes we taking for break this morning? 20 minutes. Enjoy your break. Be back here. We'll finish this after break. Then we'll go to our other topic, which is ethics. Are we ready? Okay, have your seats. Again, I'm going to start right now with the end of my presentation from the first part, and then we'll go to ethics, if that's okay with you. So here's what we have. Offshore program. Hot area, continue to be hot. Started in 2009. Just to get you what effect this has had, 300,000 people were filing FBARs in 2009. As of last year, 1,163,229 people filed them. So we had a 4 times increase in the number of people filing FBARs. So there was hundreds of thousands of people who were not reporting their foreign accounts. Those people who haven't corrected, which there's been about 70,000 so far that have come in and corrected, still have risks they'll be discovered by the IRS and could face penalties. Also, the larger liabilities should have an 8938 on them for the income tax returns, in addition to the FBAR, the 114. Last year, Credit Suisse was the biggest deal they ever made, pled guilty to a felony offense, and paid a $2.6 billion fine to the United States government for helping Americans hide money, and agreed to give up the names of their clients. And so those names are out. They've indicted over 100 people criminally since 2009. Over 190,000 foreign banks now share information with the IRS, and that's based upon FATCA, the Foreign Account Tax Compliance Act, which says essentially that banks must report American income, American accounts worldwide. And the penalty for a bank not complying is if they do any transaction with the United States bank, the US bank must withhold 30% of it. So I'm a Japanese company. I asked my Japanese bank to transmit $1 million in to keep my American subsidiary running. I don't get $1 million. The US bank that receives that money takes out 300,000 of it if that Japanese bank is not complying with FATCA. So what we've done is we've made deals with 100 and some countries where all their banks report. So all the Japanese banks report, all the British bank reports, all the EU countries are reporting. But we have some countries which are not reporting, and then if the individual bank doesn't make a deal with the IRS to report, as soon as they try to put money into a U.S. bank or get money back from a U.S. bank, 30% gets withheld. So that means that most legitimate banks in the world are now complying with ratting out Americans. The Zwerner case is interesting. The penalty for not reporting FBAR willfully is 50%. Zwerner stands for the proposition that it can be 50% per year. Arthur Zwerner, an 80-some-year-old man in Florida, didn't report his Swiss bank account, and so they found out about it. They came in and they hit him with a 50% a year penalty for 3 years. He went to trial in Florida before a jury, and in 2015, a jury came back and said the IRS could, in fact, impose a 50% a year penalty if you intentionally didn't report a foreign account. So the penalties can be huge. All Swiss banks now cooperate with the U.S. and turn over information on the U.S. depositors. About 100 Swiss banks made a deal for giving back information. All the Swiss banks currently report on Americans, but 100 of them have made separate deals to turn in Americans who were there all the way back 6-8 years ago. They're going around the globe. I was in Hong Kong over Thanksgiving. Why? Because they're going after Hong Kong banks, Singapore banks, Israeli banks, Caribbean banks. The IRS keeps expanding. And with the Panama Papers released last month, guess what? Panamanian banks are now on the target list. So FATCA went into effect effective 6/30/14. That's the Foreign Account Tax Compliance Act. Over 150 countries have agreed that all of their banks will report to the U.S. with 1099 type of documents. So if you're in have a client with a bank account in most major economies of this world, we're going to have those reports. We haven't signed one yet with Syria. We haven't signed one yet with Iraq, North Korea, but Afghanistan. But if you have a country that we are friendly with, we have a deal. India made their deal a year ago. If you have Indian clients, many Indian clients have come from a culture where in India, if you pay the right person, you don't have to pay all your taxes, and they don't fully understand that the U.S. really means it. And so the Indian banks are ratting out their customers, and some of them are in a target list. State Bank of India is currently targeted by the IRS. HSBC India, targeted by the IRS. ICICI Bank in India, targeted by the IRS. So watch it for your Indian clients. And because I have a lot of Indian clients, because they are the most successful immigrant group of any group coming to the United States over the last decade. Doctors, engineers, they come here, they come from well-educated families, families with money, and they leave money back in the home country, and they don't report it. So it's a good target market for you. Yes?
Has the FBAR filing date been moved up?
It has. It is now being, with the change in the Highway Act, they made it so that FBAR now is due on the date of income tax returns. If you take an extension, you get to October 15th. So it was June 30th. Okay. Here's the program they have. The official program has been around since 2012. In 2014, they made some modifications, so I'm using that date too. If you come in and confess you had foreign accounts before they find you, then the IRS will let you pay a 20% accuracy penalty on any income tax you owe. If you didn't file returns at all, a 25% late filing penalty. And you agree to pay 27.5% of the amount you had hidden in the foreign account. And you file 8 years of income tax returns and 8 years of FBARs. Most of my clients pay 40%. What do you get in return for that? When you get through with the income taxes, the penalties, everything else, you get a letter from the IRS saying we won't put you in jail. So what would you pay for that? And if you're under 75 grand, the penalty is 12.5%. You can come into the program, get that letter, and then say, I want to argue about the penalties. That's called an opt-out. If you do an opt-out, though, it's what I call a dirty, hairy moment. And what do I mean by that? You say, I want to argue about the penalties. They might lower your penalty to nothing or only $10,000, which is non-willful. But if they think you were willful, they hit you with the 50% penalty. So you may remember the old Dirty Harry movie where he's sitting in a diner in San Francisco. A crook comes in to rob it. Dirty Harry pulls out his Magnum 44, drops 4 slugs out of the chamber, spins it, sticks the gun to the guy's head and says, do you feel lucky, punk? That's your moment at the IRS. If you think you can prove non-willful, you can go in and argue, but if you lose, your client gets hit with the 50% FBAR penalty. So do you feel lucky, punk, is your client. So you better be sure you got a client you think was non-willful to do this. I've had success doing that. Doesn't have an expiration date. The IRS says we can stop it at any time. June of 2014, they now have a new program called Streamline. If your client lives in the United States, he can file just 3 years of income taxes and 6 years of FBARs. He has to submit an affidavit, though, proving they were non-willful. Well, I had a client come to me where he had had money in UBS Bank, and they told him, the government's after us, why don't you move to another Swiss bank? And then he moved it to another Swiss bank, which then kicked him out, and he moved it to a Cayman Islands bank. And he said, I want to submit an affidavit I was non-willful. Good luck, yes. I'm not going to win that one, but if I have an immigrant who didn't know the rules, who left money in India, moved here to go to work for a U.S. company, has only been here for 3 or 4 years, I submit this affidavit. They pay 5% of the foreign account at its highest level over the last 6 years, pay 3 years of income tax and interest, and they're fine. Every one of them's reviewed. You do not get a letter saying you won't go to jail, though. And they say if they find that the affidavit is false, they reserve the right to prosecute you for the false affidavit and the non-filing of the FBAR. So you got to be careful. So far, none of my clients have fallen off. If your client lives overseas, the penalty can be 0%. So if they're living in another country, 0%. Here's one I have for the Hong Kong clients I have. Clients came here before 1997 from Hong Kong. Why? Because the communist Chinese were going to take over Hong Kong from the British. They came here, got a green card, then got citizenship. Things stayed pretty good in Hong Kong, and they went back home. They're U.S. citizens. They're now worth $60 million. When they returned home, they never filed any U.S. returns. What's the law? Americans must file returns for all income from all sources worldwide, no matter where they live. But they were also Chinese citizens. They didn't give up their U.S. citizenship. Guess what banks are now giving up names of Americans? And so they invited me over. So we are coming in under the living abroad and asking for a 0% penalty on the $60 million. But we're going to have to pay income taxes for 3 years on their earnings. And that isn't insignificant. You know, they're only making $4 or $5 million a year in income. And so they're going to have to pay taxes on that. But they won't have any penalties. So there's also another problem. Even if you come into the official program, the IRS now has 98 banks on its list where they say, we already know about these bad banks. They're already giving us names. We won't let you have a 27.5% penalty. We will give you only a 50% penalty. You got to go to the IRS website. They add banks every week. This is as of March 16th. There were 98 banks that you can't get the lower 27.5% penalty on. So these are the banks that you'll pay a 50% penalty. And there's a list. As of May 25th, I'm sorry, March 25th, I looked this up. You can look it up now, it'll be more.
What is that percentage of?
The highest level in the account. So if I had $1 million in the account for 2 days in 2011, that's the time they'll choose it, even if I took the money out and I only have 100,000 there now. They look at the highest point ever during an 8-year period. If you didn't file an FBAR, or in some cases my client filed an FBAR but didn't tell the full truth.
What if they reported it on their tax return with the appropriate form?
If they reported it on their tax return and they reported all income, there's an exception and you can avoid all penalties.
Okay.
And that's all in the Q&As with the IRS. I do a whole course, and you can buy it from Larry, that I did last year on FBARs if you want, 2 hours of this. So if you really are interested in this, it's been the best money maker I've had since 2009. Fewer collection matters, fewer audits, but lots of Americans with money offshore, and they have money to pay my fees. That is good. Every person in this room wants a client with a lot of tax problems and a lot of money. It's like the perfect storm. Okay, ID theft. Try calling the number. You're going to be put on hold. Fax it to the fax number. It's in your materials, so I'm going to skip to next. Priority case program. I have a list in your materials of all the appropriate 800 numbers you might want to look up at the IRS. You could go in and find them yourself. I have an associate go in and update the list every year. That's over on page 40? Okay. No. Yeah, page 40. So I'd rip that out of the materials, put it in your desk drawer, and if you need an 800 number, page 40, not on the PowerPoints, in the written material. So I did a 90-page outline that's sort of added onto the PowerPoints. And you'll see that coming up now, you're going to get a lot of slides you haven't seen in there because I changed it all yesterday and updated it. Yes, sir, question?
Yeah, what's going to be the ultimate resolution? I've got a client that they have flagged his account for 2 years running for identity theft. Is that going to go on forever, or what's going to happen there?
It's going to go on forever, I think, until you got a resolution number, right?
We submitted
Yeah,
Can it be forever?
you may have to do it forever until they, I don't know how long they're going to keep it on there. Okay, now we get to the headlines. Some of this you have in the PowerPoint, and then I'm going to have some that you don't, and then we're going to do our ethics. 1, private collections coming. Congress passed a law this fall saying that the IRS has to go back with private collection, which makes no sense at all. Because the National Taxpayer Advocate reports that for the 2006-2009 period when they had private collectors, the government lost money. So why did this get passed? Because Senator Schumer and Senator Grassley, when they had private collection before, guess what states the 2 collection agencies were in? New York and Iowa. Schumer, Grassley. Guess who has received large donations from private collection firms to sponsor legislation to have private collection? So we have the best Congress money can buy, and we're going to have private collectors. Here's what we did from 2006 to 2009. This is what you'll do. Every time a private collector called my clients, we wrote a letter saying, under the Fair Debt Collection Practices Act, we refuse to deal with you. And if you have any further contact with my client by letter or by phone call, there's a $1,000 minimum penalty for your harassing my client, and we shall initiate suit against you if you do not cease and desist. When you write that letter, what happens? They send the matter back to IRS to go back into the ACS unit. Don't deal with private collectors. You don't want them to get the 25% fee. You don't want to deal with them. So just write the letter. You don't have to. So, bad legislation. This one's even scarier. In the 2015 in the Highway Act, a new section 7345 was added. And if your client gets a lien filed against them for more than $50,000, the IRS will provide that to the State Department, and your client will not be allowed to get a renewal of a passport or to get a new passport. And if the revenue officer chooses, he can request that the State Department revoke your current passport. The exception under the law is if you're in an installment agreement and you owe more than $50,000 or you have a pending offer in compromise. They have not yet issued the regulations on this, so your clients are safe right now. But as soon as the regulations be issued, think of the power that the revenue officer is going to have against your client. Oh, your client's a businessman who regularly goes overseas, and he owes us $110,000. Well, he better get all this travel in real quickly, because I'm going to revoke his passport. If they give you notice, the rules do say that they're going to have to give you notice they're doing this, and you have a right to go through some type of hearing, but it's pretty scary. But if you apply for a new passport or renewal, they'll reject it, then you're going to have to go through an appeals process after the fact. It might be worth a little letter to your delinquent clients warning them of this. It might get you some more business. Okay, now these slides are directly from the Chief Collection of the United States. They're in your materials. They are not in the PowerPoint presentation I have for you, but they are in the 90-page outline. They have a now early interaction for FTDs. And what they're doing is, for large companies that stop making their deposits, it used to take them 2 or 3 months to get out and say, why aren't you making your deposits? They're now coming out within a few weeks and saying, you're not making your deposits, here are all your warnings, including the fact we may try to set you up to be prosecuted for not making your deposits. Get involved. So they send a soft notice of $45.94. If they've missed deposits, they're limited to, and they instruct the taxpayer to call an 800 number or file form 14143. If they don't respond to that, they come in and they're coming out to see them. And in October 1st, 2015, they initiated this more aggressive program to come out with a real-time system so that if I miss a couple deposits and I'm a big company, there's going to be an alert issued, a revenue officer will come out, visit me personally, give me warnings on FTD penalties, warnings on potential criminal violations for continuing this conduct, warnings that they might do a termination assessment and end my quarter right now and start levying, and they're going to essentially educate me that I got a problem. The initial contact, within 15 days of the receipt of this compliance notice, this FTD alert is what it's called. And the revenue officers will come out within 15 days, and they initiate a field call, show up without appointment, give the people, and then the follow-up procedures are all going to be in the Internal Revenue Manual after the official contact. So that what that means, though, is they're switching more resources for these 3,000 field revenue officers from individual income tax collection to employment taxes. When they get there, they're going to explain the reason for the call, provide the taxpayer with publication one, their rights, go over all the deposits, ensure the taxpayer understands the consequences of noncompliance, including you could be prosecuted, discuss the notice of federal tax lien that could be filed against them and the levy procedures. Once they've talked to the taxpayer, they're going to make sure they're complying after that point. If the taxpayer cannot satisfy past due deposits, well, meaning current deposits, encourage the taxpayer to make deposits first while working to resolve the past. It's a dual initiative. So they're going to also look to another part, which is these payroll services that are stealing money from the employers. So they're going out and they have a new system to determine and go after these crooked payroll services. And they're going to check on PINs, and they're, among other things, if there's a change of address form that goes in for a business, they're going to notify the old address of it, because one of the ways the payroll service has been stealing to avoid you knowing that they're not paying your FTDs is they change the address of the business to their address, and so all the IRS notices go to them, and they keep stealing your FTDs every month as they do your payroll. So this is a part of a new initiative. Rare instances, use of the third party can expose payroll tax fraud, later on filed returns, on reported tax liabilities, later on deposited tax payments. I represented a guy who ran one of these places, and $6 million had fallen by the wayside. My client couldn't fully explain it, except he thought maybe it was a theft by one of his subordinates, although he was living very well. And the IRS did open a criminal investigation. They raided his business and his home, got a lot of records. And to get it to the bottom line, they recommended it for prosecution. We went to Washington. We convinced Justice Department that their evidence was insufficient to prosecute. They dropped the prosecution, and my client walked. Life is good when you're a crook and you can get your lawyer to get you off. But doesn't always happen that way. Okay. A single company is limited amount of employment tax accumulated based on the number of employees. There are employers who serially fail to pay employment taxes many times accompanied by failure to file as well. What's that? They're going for injunctive relief now. I have one pending now in Chicago. My client runs a machine shop, 20-some employees, has been regularly late filing and depositing for the last 3 years. Revenue officers said it wasn't worth taking out this small machine shop, but they filed a lawsuit in federal court, and they've gotten a preliminary order from the judge that says, you must deposit every payroll. And if my client fails to make a deposit, that's contempt of court. And he can go to jail for contempt of court. So they're literally getting court orders. Now we're negotiating some type of resolution going forward, but they are going forward on these injunctions. They've filed several hundred of these around the country against people who are regularly not making the deposits on time. And it's a federal lawsuit with a judge ordering you, if you miss a deposit, sir, I can put you in jail for contempt of court. So far, my client, over the last 3 months, has made every deposit on time, strangely enough, although he couldn't do that for 3 years in the past. And so the courts have the authority to do it. And they also look at whether they had prior ventures, where they had prior ventures they abandoned. Prosecutions. In fiscal year 2013, there were 102 employment tax evasion investigations opened with 80 prosecutions issued and 62 sentencing. The average sentence is 24 months. I understand they have over 300 opened in 2016. It is the target area, folks. Your client is somebody who has larger liabilities. I'd say somebody running up $100,000, $200,000 a year in withholding taxes, and they regularly aren't paying. They may be indicted. I've had a couple clients get to visit Club Fed. A Virginia client a year or so ago had gone 2 years without paying all his payroll taxes on his construction company with 40 or 50 employees. The judge gave him 32 months in Club Fed. Club Fed isn't that bad. It's a white-collar prison. You get a good job, 40 hours a week, 14 cents an hour. But most of your clients wouldn't want to visit it. I argued that he was 36 years old, had a young family, 3 kids, and a non-working spouse, that the judge shouldn't put him in jail. The judge said he should have thought of that before he didn't pay the employment taxes, before he bought that nice house that he paid for with some of the employment taxes that he had taken out of his employee wages, before he drove that nice car. Take 32 months. So be aware they're doing it. And with that, I'm going to stop the presentation because I got all the things to cover on ethics in your material.